All right. Welcome to Notable Approvals. I am attorney Amanda Shaffer. Before I get to our case today, quick reminder, don't forget to like us and follow us on Facebook and YouTube and Instagram, wherever you are watching. I was not centered, it was bothering me. Um, anyways, if you find this video to be helpful, make sure you hit that share button so that um, you can share it with someone else you think is helpful and get this useful information out to as many people as possible. Now, if you are a regular Notable Approval watcher, you know that I often talk about immigration cases. Well, if you did not know, we also practice family and criminal law here at the Shapiro Law Firm. And today I want to talk about a motion for contempt and explain a little bit about that, since it's a little different topic, but it's an important one nonetheless. So this is a case that we are handling that has both a criminal and a matrimonial component. The parties are still married, they're in the process of divorce, and this whole thing started when one party was arrested. Now, because the parties have a child in common and there was the criminal component, this case was put in the IDV part, which stands for Integrated Domestic Violence. And the purpose of that is supposed to be so that the case moves faster, it's more efficient, you have the same judge handling all aspects of the case. So the divorce, the custody, the visitation, the child supports, if there's any spousal support, equitable distribution, and the criminal case. And then if there's orders of protection or things like that. So kind of an all-in-one type of court. And there's pros and cons to having an IDV court, but we're not going to go into that now. That's not the purpose of today's notable approval. But in this case, after the arrest happened, and my client was the one arrested, the plaintiff, the other party, filed an emergency order to show cause, which is basically an emergency motion, and basically saying that he should have custody, she needs to have supervised visits only, kind of going through all those points. They need an order of protection, blah blah blah. So what ended up happening was, in the criminal case is over. Client ended up, she took an anger management class, and it wasn't. I can't go into the facts of this case yet because the case is still ongoing. But what I will say is that this ended up being one of those cases where the plea was to disorderly conduct, and it was adjourned in contemplation dismissal, and has now been dismissed and sealed. Nevertheless, there's an order, criminal order protection, and a Supreme Court or a civil order protection. And when this case was first started, the judge made an order that is very common in contested divorce cases, that said that neither party can disparage the other party to the child or talk badly about the other party. You can't poison your child against the other party. They have a young child in this case, especially when they're young, but at any age. And so that was this non-disparagement clause, like I said, is a common order that's put in, that the judges, even if they don't necessarily order it, it's kind of, you always say to your client, don't speak badly about, your soon to be ex to the children. It's not going to help your case. You're not going to look good. So in this case, it's been very contested from day one. My client went from supervised visits with the Children and Family Services and third parties to now she has been approved for unsupervised visits. And that's kind of how these cases progress once you prove that you really are in a danger. And in this case, there was a minor incident. I can't get into it, and I never want to downplay the seriousness of domestic violence. But certain cases, there's more serious things going on in others. And in this case, basically the parties got in a fight, things happened, and my client was on the arrested end of it. So the case has been progressing along the way we expected, and this all started earlier in the year. And I think it was maybe a day after or 2 days after the judge had issued one of the temporary orders giving the plaintiff temporary custody and those supervised visits. I got an email from plaintiff's attorney saying my client violated the order of the non-disparagement clause. And I was like, I really don't think she would do that. Let me talk to her. And she told me all the possible things it could have been. And I was like, none of that sounds like anything, but like, just be really careful. You can't talk about this divorce with your child. You can't talk badly about the plaintiff with your child, no matter how upset you are. I wouldn't talk, you're allowed to talk to other people about it, but I'd be very careful talking to anyone that is like a person in common, because you don't know what will get back to your daughter. You don't know what will get back to the plaintiff. And I remember I emailed the other attorneys right away and said, I'll take care of this. I'll make sure that there wasn't a violation and that there won't be a violation. Now, nevertheless, despite them saying it was a warning, literally the next day, they filed a motion for contempt. So what is contempt? Well, there's two types of contempt. There's civil contempt and there's criminal contempt. And for today, we're not going to talk about criminal contempt because that was not alleged in the motion. Basically, they were saying that she was in civil contempt of court. In order to be in civil contempt of court, you have to, one, have an order that exists, which has an unequivocal mandate of which the party had knowledge. Basically, all that means is that there has to be an order from the court. It has to be clear what the terms are, and the party that you're saying violated it has to have actual knowledge that it exists. That makes sense. Number two, there has to be a disobedience of that order. So one of the parties did something that goes against the order. And finally, the rights and remedies of a party in the action were prejudiced, defeated, impaired, prejudiced because of this violation. So those are the three elements three elements you need in order to prove civil contempt. And you can be punished by a fine, imprisonment, or both. Sometimes, in a case where you have custody, things like that, it can hurt your case. It's not in the best interest of a child, which is what we always look at when determining custody and visitation. And so it's not in the best interest of the child to be with a parent who is disparaging the other parent. So it can hurt. The statute says punishable by fine and or prison, which would be only up to 6 months. But the reality is that it can hurt you in other aspects if you have other things going on in your case. So in this case, there were three factual allegations or incidences that the plaintiff was alleging my client violated the order, violated the order. One was clearly it happened before there were any orders in effect. So the judge actually wrote, even if it didn't violate the order. What she said, basically, she's allowed to tell other people she's getting a divorce. That makes sense. You have freedom of speech. You're even allowed to tell people it's a contentious divorce. And in this case, part of the allegations was that she said to somebody in common, I gotta go, because she was in the community, and if there's a temporary order of protection against me, or a restraining order, if I bump into the plaintiff, then I'll be found in violation. I can't stay and talk. So that's pretty much all that was alleged that she said. But for the first one, it was just that she was getting divorced and was contentious. Happened before the order was in place. Remember, element number one, there needs to be the existence of an unequivocal mandate that the person allegedly in violation and has knowledge of. The second thing that they alleged was that my client said to another person in common that about the restraining order. And then the third was that one of the child's friends asked the child a question, and the nanny overheard her ask the question, and the child responded something, like daddy is mean to mommy or something like that, one of those types of things. And my client was actually having a supervised visit with the nanny at the time and did immediately stop the conversation and say, she knew she didn't add to the conversation, kind of stopped it and redirected it. And she actually did the right thing, but then, the nanny trying to do the right thing told the plaintiff, and the plaintiff then said my client violated the order, but there was actually no evidence to show that my client even spoke poorly of the plaintiff in any way, shape, or form. So basically, when we saw this, we were very frustrated because we had been dealing with this case for a few weeks at that point, and there was a lot of work that went into it, and we felt that the motion itself was frivolous, that it was very clear that the plaintiff had no direct knowledge of my client disparaging him to the child, or talking about the litigation to the child, or to a third party that with the intention of reaching the child, even though it didn't prohibit third party communication about the order, etc. So it was just a frustrating thing to receive. But when you see something like that, say, okay, motion to dismiss. So we filed the motion to dismiss, and of course we asked for attorney fees, sanctions, cost, because we felt there really was no basis in fact here, that this was kind of being done just to make my client spend more money on attorney's fees and kind of get her to give up, if you will. A lot of times litigation, especially contested divorces, can go on for a long time, and sometimes these tactics are legitimate and sometimes they're not legitimate, meaning they're done to delay, or they're done to make it the other person's life, the other party's life, miserable. So in this case, the court technically granted our motion to dismiss. The judge actually dismissed their motion, saying, basically agreeing with us that there was no violation. No violation occurred, no facts that the plaintiff claims that the plaintiff didn't claim any rights were prejudiced. The plaintiff did not state any of the facts that actually could be seen as a violation of the order. And my client wrote an affidavit in response and explained all three situations, like provided context, saying that, look, I didn't, this is what I said, this is not what I said. And the plaintiff even admitted, and the judge noted that, look, I don't know what the defendant said about me, I'm just worried. But being worried someone's going to disparage you is not grounds for contempt. Knowing the person disparaged you and having evidence is grounds. So there was kind of, if you heard the term hearsay, where somebody says somebody else did something, is what that happened here. But it was somebody said somebody else. There was two somebody said somebody else did something, and there was one that somebody said somebody said somebody said something. So I say hearsay. It's like hearsay within hearsay. So circumstantially, there was no direct evidence, no indirect evidence of any type of contempt. So it was, we were relieved that we won the motion. Honestly, I had zero doubt from day one. I always tell clients that when we're looking or deciding motions to file, we never file motions to dismiss if we do not feel that they're going to be granted. Here we felt very strongly that would be the case, and we felt it was the right move. And we also felt, okay, we should get attorney's fees for this because they shouldn't have filed this in the first place. And then, because this was so contentious at the beginning, we did ask for sanctions and costs, and that could be levied against the party. It can be levied against the attorney, or for both. Now, if I were the plaintiff's attorney, I never would have filed this motion. I think it was not the right thing to do because it was clear that no violation occurred. And the judge agreed with us on everything, but said no attorney's fees because the clients are able to pay for it themselves, and the law basically gives the judge discretion or leaves it up to the judge to decide if one side or another should get attorney's fees. Both sides had requested them. Usually the winner gets attorney's fees, if anyone gets attorney's fees. So in this case, the judge said the statute says look at the financial circumstances surrounding the parties and didn't feel it was appropriate. We could appeal it. It's not probably won't, because whenever it's discretionary, it's very hard to win. Plus, it's just not worth it, and it's extra litigation. And then the judge said that there was no basis in fact, there was no any real evidence that a violation occurred, but didn't go to the extent to say it was frivolous. When a frivolous filing is one that lacks any merit or any basis in law or in fact, or is basically flat out lying, or is really only meant to delay the proceedings or harass the other side, something like that. And we don't have any evidence. We do feel that it was filed to put my client in a financial hole as much as possible. But how do you prove that? And this, we actually didn't even have oral argument or trial on this. This was all submitted on papers. So our main claim about being frivolous was like the plaintiff admitted that he didn't even know anything she said other than I'm getting a divorce. It's a contentious divorce, and there's a restraining order to two different people and not directly to the child. And there's no evidence she ever disparaged him to the child, and that's all the order said. You can't talk bad about each other to the child or about the divorce. So the judge said it lacks merit, but it doesn't rise to the level of frivolousness, which is a very high burden of proof. And then in terms of sanctions or costs, which are also something that are very, very hard to get. And I told my client in this case, I said, look, I mean, if it were up to me, they'd be sanctioned. But the fact of the matter is that usually it takes a lot more than that. There has to be there's someone's completely lying about something. The judge said because the plaintiff said it, that if his reputation was impugned, or he lost his good reputation in the community, it would hurt the child, and that was therefore even though it didn't have any facts to back it up, that's a conclusion, not a factual allegation. There was an attempt and therefore not frivolous. We did look into whether we should appeal it or not in that case, but we did win. So you kind of want to take your win sometimes and move on. But I have clients ask me this all the time. Can I get attorney's fees? Can I get sanctions? Can we get sanctions or costs? And it's very hard to get. And this is not the first time that I've had a judge write in an opinion. If the other side, basically if plaintiff does this again, file something similar again that lacks this much merit to it, that is kind of just like it was like a sliver of merit. That's all there was here. Then they're going to be likely to face sanctions and costs. And again, that I always feel those should be on the attorney, because the attorney shouldn't have filed it. But what do I know? I'm not a judge. Not up to me. So it was a big win that big wins don't always feel like big wins when you don't get everything you want, but we definitely got the main thing we wanted, which was to show that my client did nothing wrong, and that it makes the other side look pretty bad because they filed this motion and there's just really no merit to it. Would I wish the judge went farther? Of course. So the question is, when do you file these motions to dismiss? When do you file contempt motions? Obviously this is all very fact specific, and it's not easy to say when you should or shouldn't. But you have to look at you have to be realistic and look at the law. And like I had at the very beginning of this episode of notable approvals, I listed the 3 elements of civil contempt. And if you don't have those 3 elements, you don't file it. Now, with the motion to dismiss, there's different things, different basis you can file a motion to dismiss on. We said there was failure to state a claim. Basically, even that means that if you believe everything the plaintiff said was true, even if he got every fact right, he still cannot prove that she committed contempt or violated the order. So that's different than saying it lacks merit, but although it definitely feels like the same, because you're saying this person didn't even state a claim. So if they don't state a claim, that means the judge will dismiss it, but you have to believe all the facts are true. You assume all the facts are true. I mean, we did dispute the facts, but the facts really weren't that untrue. They just lacked context, which we gave more context to, and that helped us because it showed further that my client didn't do anything wrong. And then another little thing in this motion that was a little strange was the other party also asked as part of the punishment for the contempt was that my client be prohibited from, basically it's called a gag order. They didn't write the word gag order, but it's essentially a gag order. They were saying that she can't talk about the divorce to anybody, can't disseminate or show anybody else any paperwork involved with the divorce. And that if the judge had found her in contempt or even not and agreed to do that, that would have been appealable because that's a violation of my client's freedom of speech. You are, of course, allowed to talk about your divorce. The one thing that isn't a violation is you cannot talk about it to the child because you put your child in the middle of it and that creates problems. And like I said, that's a perfectly normal clause. So the judge did agree. Not even did agree. The judge said that plaintiff didn't even cite a law as a basis for saying that the judge can even grant that type of relief for civil contempt. And I did look up the case law on this, and it was very interesting because usually when you see gag orders, it's with really famous people. And it's with people that I guess the big divorce going on right now, Tom Brady and Gisele Bündchen, if they tried to say, well, we don't, this is going to be so high profile that we don't want the public to know, because these are public proceedings. Anybody can find out information. Anyone could be in the courtroom. So when it comes to divorce, family court's different, but this is divorce or civil court. So if Gisele Bündchen and Tom Brady had felt that they needed a gag order because the other person was, poisoning them against them. And I mean, usually you see it more with a jury trial, gag orders, but basically all of the case law that existed had to do with people who were really famous. And even in those cases, the court said, you know what, the public has a right to these hearings. We have to really show that there's going to be prejudice unless a gag order is put into place. So there was that part. I don't even know if we may have just addressed it in a sentence saying they're not citing any case law. It violates their First Amendment rights. Done. Judge agreed. So when it comes to filing motions for contempt and motion to dismiss, which are kind of, extra things that can go along with the case and make your case more expensive, you're always taking a big risk. So you want to make sure that whatever is going to be filed, that you're going to win. And we work very hard here at the Shapiro Law Firm to analyze all of the facts and all of the law, and then, present it to our clients and help us make an informed decision. Ultimately, this is an attorney decision what to file, but we always value our clients' input, and we make sure that they understand because they're going to be paying for it or not paying for it. And in this case, we obviously had no chance. We had to defend her, and we won. The case is still ongoing. It's progressing nicely, and we hope that this is something eventually, despite how contentious it started, that we can settle. And I hope to give an update on this case someday soon. Until then, I hope that this little primer on contempt or civil contempt was valuable and informative. And again, if you did find it valuable or informative, or know someone who may find it that way, please hit the share button. If not, don't forget to like us. Well, I say, if not, you should. I hope you find this informative at the very least. In addition, make sure to hit that like button or follow button on Facebook, YouTube, Instagram, wherever you are watching, so you don't miss any more of our lives. That is all for today. Thank you for watching, and have a great day.